In 11 years, Virginians will witness the dawn of a new century. Virginia, like the rest of America, is changing. Technology, medicine, communications, growth and development are transforming how we live, work, and think in ways we can hardly imagine.
All rise.
Also, like the rest of America, Virginia is becoming increasingly litigious.
Be seated, please.
Our courts, if they are to continue to serve, must plan for the changing needs of our future society.
To help Virginia's courts meet the challenge of the future, I appointed a 34-member commission to develop a vision of an effective judicial system in the 21st century. Chaired by Robert O'Neill, President of the University of Virginia, the Commission on the Future of Virginia's Judicial System began its work in November 1987. For the first time, Virginia citizens, business leaders, legislators, state and local officials, judges, lawyers, and court personnel met to assess the demands likely to confront the courts in the future and to recommend ways to meet the expected requirements. This report, published in the spring of 1989, is a significant milestone.
One of our forefathers, Thomas Jefferson, recognized both the importance of tradition and the claims of the future. More than 200 years ago, Jefferson wrote, "I am not an advocate for frequent changes in laws and constitutions, but laws and institutions must go hand in hand with progress of the human mind. As new discoveries are made, as new truths discovered, and manners and opinions change with the change of circumstances, institutions must advance also to keep pace with the times."
We wanted the Commission to be as fully representative of the Commonwealth as possible. We did include a number of judges, legislators, and public officials. We also included lawyers from a variety of different kinds of firms and communities. We also included several just plain citizens, people who represent the population that comes into contact with the legal system but isn't part of it. In this way, we had about as representative a group as one could ask. We held in the fall a series of hearings on the same night all across the state. We expected to have, and we did have, testimony from experts inside and close to the judicial system. We also had some very helpful testimony from citizens who spoke for victims and witnesses and other users of the court system. Their sense of what they'd like their court system to be was very helpful and influential to us as we worked toward our final report.
Commissioners were asked to envision an ideal justice system for the next century, to describe its components, and to suggest ways it would differ from today's court system. Debate was lively and sometimes heated, and decisions were not always unanimous. But through research, analysis, and discussion, the Commission forged a plan which preserves the historic core of the Virginia judiciary while suggesting the changes necessary to meet the needs of the next century.
Society is changing at an unprecedented rate. Life in the 21st century will be as different from today as our lives are from those of our forefathers 100 years ago.
25 years ago, only 4 million people lived in Virginia, many on farms or in small towns. By 2030, more than 8 million people will live in Virginia, at least 3 out of 4 of them in urban centers. Many will be immigrants from Asia, Central America, and Mexico, who will bring with them new outlooks but little knowledge of our judicial system. Many others will be elderly as the baby boomers grow older, who will bring to our courts new and different demands. Poverty, drugs, and rising crime will require extraordinary commitments and creative solutions from the justice system. Virginia's economy, once centered around agriculture and basic manufacturing, will be forever changed by global competition. An increase in multinational companies may produce expanded litigation in international business and finance. Experimental technologies and medical and scientific advances will create complex challenges for Virginia's courts. Growing worry about the environment and an increasingly concerned consumer movement will force the courts to consider complicated environmental and social issues. All of this will affect the court system at a time when competition for public resources will be intense. Current emerging trends project a future filled with change. Virginia must integrate the inevitable changes of the future with the traditions of the past, which for 200 years have preserved the rule of law and protected our rights and liberties guaranteed by the constitutions of Virginia and the United States.
For over 200 years, the mission of the Virginia courts has been to resolve disputes. No matter what happens in the future, the Virginia courts must continue to provide a responsive, accessible, and independent forum for the just resolution of all disputes.
One vision we foresee for the future is a judicial system in which all Virginians have effective access to justice. This includes the opportunity to have their disputes resolved without undue hardship, cost, inconvenience, or delay.
Court facilities should be built or renovated to provide convenient access to judicial services. Court forms and procedures should be simplified, and court records made accessible from computers in libraries and other public buildings. Economic barriers to legal representation should be eliminated by increased support for legal aid and greater pro bono participation by members of the bar. Undue court delay impedes factual recall, and it must be reduced. The Commission recommends adoption of time standards for all types of cases.
Although perfect resolution of every dispute is impossible, the courts must provide a fair process that is equally applied. Due process and equal application of the law should eliminate disparate treatment of litigants.
The jury system must be strengthened by eliminating all automatic exemptions and by improving representativeness and randomness in the jury selection process.
Do you agree?
Unanimous verdicts should no longer be required in civil cases. The Commission recommends that a 75% majority should be sufficient. Sentencing disparity should be minimized by eliminating jury sentencing and by providing judges with historical sentencing data.
Historically, government has met its obligation to assist people in resolving disputes peacefully through adjudication within the courtroom. But today, and even more so in the future, people are turning to alternative means of dispute resolution, such as arbitration, negotiation, conciliation, mediation, and even summary jury trial. If the court system is going to continue to play this principal role in resolving disputes, then it too must incorporate these other means of dispute resolution into its basic structure.
Virginia should create an Office of Alternative Dispute Resolution Services to develop court-supported alternatives to formal procedures. Public funds should be committed to provide various forms of mediation, arbitration, and other innovative dispute resolution devices, such as the summary jury trial. Encouraged and supervised by the courts, these less formal ways of settling differences can supplement the complex intricacies of lawyers and judges adjudicating disputes in the formal court system.
The courts are going to be faced with all types of new and complex issues in the future. And in order to effectively carry out their mission, the courts are going to have to use imagination and leadership in controlling and managing their dockets. It's clear that the courts of the future must assert control over the flow of cases through the courts.
The mission of the judicial system is to resolve disputes quickly, economically, and fairly. If this mission is to be achieved, the The court system must be organized and structured so as to promote this objective. This means that we must avoid duplication of resources and must concentrate our available resources where they can do the most good.
The Commission recommends that Virginia's trial courts be reorganized from a two-tier into a single-tiered trial court with different divisions. Suggested divisions would include one for most matters now handled by the Circuit Court, one for matters now handled by the General District Court, and one for family matters. The jurisdiction of the Court of Appeals should be expanded to include all civil appeals, leaving the Supreme Court free to focus on cases of major significance and to shape the common law of Virginia. Appeals from the trial courts should be to the Court of Appeals as a matter of right in both civil and criminal cases. Further appellate review by the Supreme Court would be within its discretion by writ of certiorari.
The courts of Virginia must be administered according to sound management practices in order to foster the enhanced use of public resources and the effective delivery of court services. The judicial system is a public entity, and as such, it's accountable for its use of public funds. This accountability requires a constant process of self-assessment and public scrutiny.
The Chief Justice of Virginia should remain the administrative head of the system. The administrative operation of the court system should be under the direction of one policy-making body, the Judicial Council. The operation of the court system should be state-funded with the exception of court facilities. The Virginia Constitution should be amended to abolish the office of elected clerk of court. Court-related duties should be transferred to the court administrator. Non-court-related duties, such as issuing marriage licenses, should be transferred to the executive branch.
If you want to have an excellent judicial system, you must have excellent judges. In order to attract the most able candidates to pursue judicial careers, the selection process must be designed to call forth the best candidates, and the gap between compensation in the judicial sector and compensation in the private sector must be narrowed.
The Commission recommends that Virginia adopt a new judicial selection system using judicial nominating commissions selected by the legislature. The commissions must nominate candidates who can function in the increasingly diverse roles required by judges in the future. Procedures should be established to systematically evaluate judges, and compensation should be increased to levels reasonably comparable to those in the private sector. Pay increases, training, selection, and evaluation must ensure that highly qualified court personnel are at all levels of court work in the future.
Our vision of the future includes a court system that is electronically connected. And by this I mean one where the courts can communicate with one another electronically, and that the people that use the court systems will be able to communicate electronically. And this includes being able to file suits from remote locations, be able to get information about the courts and pending cases from remote locations, such as libraries, offices, and even the home. It's also very important that we not allow technology to deprive the courts of their sensitivity to the people that use the system, and be ever mindful that our purpose is to serve the public and to reach proper conclusions or fair results based upon the evidence in each particular case.
Virginia's courts should be equipped with the latest computer hardware and software to optimize the use of the court's resources, technologies compatible with those used in law offices and businesses. Videotapes should become the official court record. Live testimony in a courtroom should remain standard for most cases, but if conditions warrant and parties agree, hearings and trials may be conducted using interactive telecommunications. Computer automation should allow cases to be initiated and records retrieved from remote locations.
Through an independence forged over the centuries, courts have been the primary protector of our rights and liberties as guaranteed by the Constitution. For them to be able to continue to fulfill this vital role in the future, they must maintain the respect, confidence, and trust of the public by being better understood, more accountable, and more responsive to the needs of our citizens.
The citizens of Virginia have to have confidence in the courts and high respect for the law. And that confidence will be based not only on the judgments the courts reach, but the way those judgments are reached. The citizens have to be convinced in civil disputes that both parties have been dealt with equitably, and in criminal actions that justice has in fact been done in order to enhance respect for the law and deter crime.
The Commission recommends broad access to court records and proceedings, including television coverage. The court system also should develop a consumer research and service development process to monitor citizen concerns. In this way, public opinion can be translated into specific products and services to help citizens make more effective use of their legal system. Victim witnesses must feel that the system works in their favor, fairly and considerately. A comprehensive program should be undertaken by the courts, bar, and General Assembly to educate all Virginians about the court system. The Commission suggests the creation of a public corporation known as the Virginia Law Institute. The Institute would monitor social, economic, and legal forces and conduct an ongoing study of substantive and procedural law.
We believe deeply in the principle of separation of powers. In order to do their job, courts need to be independent of other parts of state government. They have to work with the executive and the legislative, but they do so in a separate, distinct, and independent sphere. That's the principle of separation of powers. It's a principle that we reaffirmed throughout our work and all through our report.
The report of the Commission on the future of Virginia's judicial system expresses a philosophy which will serve as the foundation for practical action, whether the future evolves according to expected trends or confronts us with the unanticipated. It presents a vision of the preferred future and represents a blending of our expectations of what will occur with our dreams and aspirations for what should occur.